Good morning, everyone, and welcome to this meeting of the Licensing Subcommittee. The first item on this morning's agenda is the election of a chairman. Can I ask members if there is any proposals, please? Councillor Keddy?
I would like to propose Councillor Flagg for chair of the subcommittee today.
Thank you, Councillor Keddy. And Councillor Richardson, are you happy with that? Thank you. Thank you, members. Item 2 on this morning's agenda, apologies. To receive apologies for absence from members. Clerk, are you able to?
Thank you, Chair. So we've had apologies from Councillor Mark Cowell and Councillor Chris Matthews, who was the first reserve. Councillor Judy Richardson is as second reserve, is stepping up and is now a member of the subcommittee. Thank you. Thank you.
Item 3, declarations of interest. Do members have any declarations of interest regarding the items on the agenda this morning? Councillor Keddy?
I do not have.
I have no interest.
Thank you, Councillor Richardson. Protocol for public speaking. A protocol for public speaking at formal in-person meetings of the Licensing Subcommittee is included with the agenda sheet for this morning's meeting. Can I ask the clerk to just run through the housekeeping, please?
Yes, certainly. So it's just a reminder to everybody, if you can, to turn off mobile phones and other devices that might make a noise during the hearing. For people in the room, if the fire alarm sounds, then we will exit by the nearest available signed fire exit route and convene in the Braidley Road under the Braidley Road flyover. And just also to remind everybody that we are broadcasting this meeting on the council website for live and subsequent viewing until we exclude the press and public later on in the meeting. Thank you.
Thank you. Moving on then to item 5. For your eyes only, 134140 Old Christchurch Road, Bournemouth, BH1 1NL. An application has been received for the renewal of the sexual entertainment venue licence for the premises known as FYEO. 134140 Old Christchurch Road, Bournemouth, to permit relevant entertainment to continue for a further 12-month period. The licensing authority has received 2 valid objections. The matter is brought before the licensing committee for determination. I will now ask each participant to introduce themselves and state their role. I'm Councillor David Flagg, elected chair and member of the subcommittee.
Councillor Alistair Keddy.
Councillor Judy Richardson.
Thank you, members. Councillor Adrian Chaperon-Law is joining us this morning for training purposes on Teams, and we also have in the room the Vice Chairman of the Licensing Committee, Councillor Sandra Moore, who's also observing for training purposes. Mrs. Sarah Rogers.
Good morning. Yes, Sarah Rogers, Senior Licensing Officer, BCP.
Thank you, Sarah. Mrs. Linda Cole.
Good morning. It's Linda Cole, Legal Advisor to the subcommittee this morning.
Thank you, Linda. Miss Jill Hollyoak.
Hi there, I'm Jill Hollyoak, clerk to the subcommittee. I also have 2 colleagues from Democratic Services, Rebecca Rhodes and Sinead O'Callaghan, who are observing for training purposes today. Thank you.
Thank you. For the applicant, I have Miss Julia Palmer and Mrs. Emily and Mr. Alex Ivins.
Good morning, members of the committee. Julia Palmer speaking on behalf of the applicants, and I have immediately next to me Emily Ivins.
Good morning.
And behind her is her husband, Alex Ivins.
Morning.
Thank you, Miss Palmer. We have 2 persons objecting to the application. First of all, Mrs. Susan Stockwell.
I am Susan Stockwell.
Thank you. And Councillor Lisa Northover.
Hello, I'm Councillor Lisa Northover.
Thank you, Councillor. Members, before I run through the procedure, please may I check that all persons who have given notice of their intention to speak have been identified, and any person who wishes to withdraw a representation or wishes not to speak has been identified. There are no comments, I'll take that as correct. Thank you. I will now explain the proposed procedure and order of speaking for the hearing as follows. The licensing officer represents the report. Questions of the licensing officer by all parties. Members of the subcommittee to go first. The applicant will make their application. Questions of the applicant by all parties. Members of the subcommittee to go first. Objectors will make their representations. Questions of the objectors. Members of the subcommittee to go first. All parties will be given an opportunity to sum up, with the party who spoke last, the objector, to go first. The hearing will then conclude. The subcommittee will deliberate in private with the legal advisor and the clerk present. Notification of the subcommittee's decision will be given, where possible, within the period of the 5 working days, beginning with the day or the last day on which the hearing was held. The notification of decision will include information about the right of appeal as appropriate. I will now ask all parties to confirm agreement on the proposed procedure or make representations. And once again, if there is no comment, I will move forward. Finally, please may I remind all parties speaking not to repeat the information which they have already given in writing, but to expand on their written representations. All questions are to be asked through the chair, and there will be no cross-examination of parties. I will now ask the licensing officer to present the report. Sarah Rogers, please.
Thank you. So as we've heard, this is an application that's made by Hampshire Restaurants Limited for the renewal of the sex establishment licence, sexual entertainment venue licence held at Old Christchurch Road for a further 12-month period. The premises have had the benefit of a sexual entertainment venue licence permitting the live performance of nudity, also known as relevant entertainment, and have been operating as an adult lap dancing club for over 20 years. The current licence holders have been operating the business since approximately 2015. The application made complies with relevant legislation, and the necessary site and newspaper notices were published in accordance with that legislation. As a result, 2 objections were received. The applicant has been actively mediating with one of the objectors in an attempt to resolve all of the concerns raised. Any decision to refuse this renewal application must be relevant to mandatory or discretionary grounds as set out in my report. There were no objections from Dorset Police, the Fire Service, Environmental Health and Trading Standards, who were also consulted on this application. Thank you.
Thank you. Members, are there any questions for the licensing officer, please? Councillor Kelly.
Not at this stage, Chair.
Thank you. Councillor Richardson.
Not at this moment.
Thank you. Can I call on the applicant, please, to address the committee?
Thank you, sir.
Beg your pardon. Are there any questions for the licensing officer before I move on?
No,
Mrs.
sir, thank you.
Stockwell. Miss Stockwell.
Yes, I have a question, and it wasn't in the verbal report just given, but last night I noticed in the pack on the BCP website relating to this this hearing that there's a statement that there is a presumption, a legal presumption, that licenses should be granted, these licenses should be granted. Now, I only noticed this last night, so I apologise for not raising it sooner. I sent an email off to the officer, which I quite understand may not have been seen. There was very short notice, suggesting that there isn't a presumption that the licence should be granted. And I wonder if we could have some clarification on that, although the officer hasn't included presumption that the licence should be granted. i.e. that you've that objectors then got an uphill struggle against the presumption it should be granted. Perhaps you could clarify that point.
Thank you, Mrs. Stockwell. Sarah?
Yes, well, there are the mandatory and the discretionary grounds for refusal. So I did ask Linda to clarify, because I did get your email this morning, but it's my understanding that it is as set out in the Local Government Miscellaneous Provisions Act, Schedule 3.
Thank you, Sarah. Can I ask Mrs. Cole to
I've only just read your email, Sarah, so I've not looked at it properly, but I mean, I will take a time when we're in deliberations to look clearly at it. I mean, I don't think it really makes an issue for the hearing. I mean, we will be following Schedule 3, definitely.
Thank you. If there are no further questions, can I call upon the applicant, please, to address the committee?
Thank you, sir. Firstly, I confirm that I have no questions on the report. So bearing in mind the indication that you've given that you will obviously not want a repetition of all the written representations and responses you've had, I shall try to keep my address to you today succinct, knowing that you have kindly read the response to the objections and the subsequent email exchange between Ms. Stockwell and myself. I represent the applicant company and have represented the operators of this venue since it first opened in the last century in 1998. Throughout this time, there has been considerable financial and personal investment in the club, ensuring that it continues to operate at the highest standards in all respects. This has been evidenced in the club's regular accreditation in the Best Bar None Awards. This has also been evidenced by the fact that no statutory authority, nor any local business or resident, has objected to any of the renewals of the licenses to enable it to operate as a lap dancing venue for the past 24 years, including this year. It has, of course, only been subject to the legislation that requires it to have a sexual entertainment venue license since 2012. That legislation properly permits objections to the requisite annual renewal, and you are aware that 2 objections are before you today. You've also heard that it provides that refusal to renew an application can only be made on the grounds set out in the Act. If you find any one of those discretionary grounds, there are mandatory grounds and discretionary grounds. Should you find a discretionary ground, you are not obliged to refuse, but you have the ability to refuse. You are familiar with those grounds, and they have been helpfully set out at page 11 of your report. I would respectfully submit that the only ground that is relevant before the committee today are those set out at paragraph 12(3)(d) of Schedule 3 of that Act, and I will limit my address to that particular ground. If you disagree with this contention, sir, please could you advise me at this juncture so that I may address you on any other issue you believe is relevant. You will be aware that the applicant has responded, as I said before, to the issues raised by the objectors, and the response is set out in your report at Appendix 7, and that's pages 47 to 58. And and the subsequent email exchange is also there. As all parties have this report before them, As I say, I will not rehearse it in full, but of course we are always willing to amplify or answer questions on the content of the response. However, because your attention is drawn to the discretionary ground for refusal at paragraph D, and that is that the renewal of the licence would be inappropriate, having regard to the character of the locality, the use to which any premises in the vicinity are put, or the layout, character or condition of the premises in respect of which the application is made, I shall more specifically address you on that. With regard to the character of the locality and the use to which the premises in the vicinity are put, we have an advantage that the committee has very recently carefully considered this issue, the character of the locality and the use to which premises in the vicinity are put, in respect of the application to renew the sexual entertainment venue licence for Wiggle at 159 Old Christchurch Road on the 22nd of June this year. They were satisfied that there had been no material change in the character of the locality or use of the premises in the vicinity at the time of that decision. I do fully accept that each application will be considered on its facts and merits, but we do note that advantage. The committee will be aware that the applicant has in fact addressed various issues raised by the objectors under those two headings in its response, and we would respectfully submit that there has been no fundamental change in the area in the past 4 months, which would cause a committee to reconsider its findings in this respect. I am, of course, most willing to address the committee in respect of these issues if you disagree with that contention. With regard to the layout, character or condition of the premises, some issues have been raised, which, as I say, have been responded to. The photographs at pages 54 to 56 of your report are very clear and show the subdued decoration of the frontage that has been able to be carried out now that the issues with the landlord have been overcome, and the lack of any explicit signage. We would respectfully submit that this discreet appearance is not only inoffensive, but it is actually one of the better presented premises in this particular area. For Your Eyes Only continues to operate as it has done for decades without issues and with a strong team at the helm. It is a trouble-free and safe venue which continues to contribute responsibly to the nighttime economy of town. The issue of public sector equality duty has been raised, and you will have again read our response in this respect in the last 2 paragraphs of page 49. We would emphasize in particular the promotion of equality amongst customers, and we do confirm that couples are very welcome, and indeed the women quite often wish to return because of the atmosphere of the club being so conducive and appropriate for them. And we would also wish to emphasize that the main director of this company is unusually, as you will see, Emily Ivins. Thank you, sir. I'm willing to take questions on any of those issues.
Thank you, Ms. Palmer. Do members have any questions of the applicant at all? Councillor Keddy.
Good morning. I take on board the need to focus on the discretionary grounds in section D. In terms of the character of the relevant locality and fundamental changes to the area. It is mentioned in the report that we now have the Livingstone Academy, and we have a great deal more school children that walk past the venue. In terms of the layout, character and condition of the premises, I passed by last night to take a look at the outside of the building. I was quite satisfied that it is in good condition. The text below the logo describes the venue as the Premier Table Dancing Club, or words to that effect. That implies I'm a little concerned that the use of the word table dance of the phrase table dancing, as children could ask questions. I'm not sure how I would answer my 9-year-old if she asked me what a table dancing club was when she was walking by. Those, if you could address those two items. Thank you.
Of course, sir. Thank you. I'll deal first with the Livingstone Academy. That, of course, was raised at your previous hearing as well on Wiggle. It is still getting underway, as it were. It's not got its full complement yet. We note that. We also note that the hours that academy will be open will not conflict with the hours that the club is open. Our club is open. So it may be that some of the people attending, or the children attending that academy, may walk past the club when they're going to school, but it will be closed. So it will just show a passive frontage. I would have thought that the majority of pupils attending that academy are likely to come from the Lansdowne area where their transport drops them off and the like, rather than the square area. It's a much longer walk from the square right up through Old Christchurch Road. So I think it would be a small number of pupils. We know that there are only a few pupils there, as I say, at the moment. I do accept that will increase, or is intended to increase, although it's not happened at this time. The prime thing is that the two operations are completely separate in time. With regard to the text, so it is only appropriate that the operators of establishments such as this be allowed to let people know what is within the establishments. There are strict conditions on the license preventing inappropriate displays of what goes on, as it were. And you will note that this club has none of the images, if I can put it like that, that some other clubs may have in this or other areas to indicate to the general public what is going on. I would respectfully submit that this is just about as discreet as could possibly be managed without, and still let people know what is available. Some people obviously want to go to that entertainment, and they would like to be able to understand what does go on. As for children perhaps asking, they will obviously need to be old enough to read the inscription and to ask the question. And I'm sure then that a parent could give an appropriate and acceptable response to that.
Thank you.
Thank you, Ms Palmer. Councillor Richardson, do you have any questions for Ms Palmer? Thank you.
The premises were visited in March 23 and a point was made that the dancers were becoming too close to the customers and this needed to be managed. Has that been resolved?
Thank you, Mark. Thank you. Yeah, yes, indeed. After that was brought to my client's attention, the manager at the site undertook what they call reinduction, a retraining of all of the dancers immediately, and that was before their standard 3-month induction or reinduction was due. So it was done straight away to emphasize it. As I say, they are reinducted every 3 months anyway to remind them of the rules. And with regard to the dancers who, on reflection, were perhaps not being entirely within the rules, just a little bit too close, their records were marked as having had a warning following their reinduction, and in the event that any behaviour is noticed that causes concern, they will have sanctions against them and will no doubt not be allowed to dance again at the club. So taken very seriously, dealt with immediately, and ongoing supervision of that.
Thank you.
Thank you, Ms Palmer. Councillor Northover, can I ask, do you have any questions for Ms Palmer at all?
I do, please. Yes. Shall I just go ahead?
Yes, please.
Thank you. I understand that the dancers are not employed but are self-employed, and I would like to know how much they pay as a floor fee if you have a system like that in place. And then I have a couple of follow-up questions after.
May I just take instructions on that briefly, sir? Thank you.
Yes, before you do, I'm not sure that that's relevant personally. But,
I can
please.
explain why if first, if that's okay.
Yes, please, councillor, and then I'll ask.
Because I've seen in where people have looked into the way that the lap dancing businesses work, that where dancers are paying a floor fee, because they have a need to make enough money to cover their expenses, it can often make a competitive environment, which does lead to dancers then pushing rules or breaking rules. And so I'm wondering if there are floor fees in this establishment, and that might explain why rules are not stuck to.
Thank you, Councillor Northover. Ms Palmer, please. Ms Palmer.
Thank you, sir. I'm advised that on weekdays there is no floor fee, and but there is a commission on the dances that are due, and at the weekends there is a flat £30 floor fee. Is that right?
That's correct.
Yes.
Thank you for that. Councillor Northover, do you have any further questions?
No, that's fine, thank you.
Thank you. Mrs Stockwell, did you have any questions for? Thank you.
In the beginning of the report from Ms Palmer, I noticed the use of the word only in the description of what the councillors can refuse a licence grant on. Now, I may be mistaken, but I have scoured the legislation and I cannot find the word only. So I would like to know where that word only has come from, because I don't believe it has any legislative force or significance.
Ms Palmer?
I'm sorry, sir, I'm having some difficulty understanding the question. Are you referring to our my written response?
I'm referring to the suggestion that the only grounds on which a licence can be refused are those in the 1982 Act. Whereas I say, well, I will say later, I prefer not to get into that now, what else I would say later, that other legislation is relevant to a decision to refuse. And I was listening very carefully for the word only, and I heard it. And I would like to know the justification for using the word only, that they're the only grounds.
Thank you very much. This application is made under and will be considered under the Local Government Miscellaneous Provisions Act 1982 and Schedule 3 of that Act, and it is that to which I am referring.
Thank you, Ms Palmer. Do you have a further question?
Only to say that I don't accept that that legislation includes the word only in the description of reasons for refusal. And I appreciate that that is not
As a statement rather than a question. Thank you. Are there any further questions at all for Ms Palmer? Can I ask, would Mr and Mrs Ivins like to address the committee at all?
Would you like to address the committee at all? Sorry? Would you like to address the committee at all?
No, fine, thank you. So thank you, not at this juncture, thank you.
Thank you. I move forward then to the objectors to ask them to make their representation. So not sure who would like to go first. I've got Mrs Stockwell down first. Thank you.
I am objector one, yes, it's the lengthy one. Thank you. Thank you. Firstly, I note the point that the committee is not wishing to hear the entire objection which I filed in full, and I respect that. However, I would like to just make absolutely clear that the fact I don't go in detail to every point doesn't mean that I'm withdrawing any of those points. So in summary, I say the location of this establishment is unsuitable, and I would ask the committee to think in terms of if their child or if their resident's child were to arrive in another country or another town to study at university, how their residents would feel if the local authority had allowed a strip club to be operating directly underneath their daughter's place of residence, or at the rear of the strip club where there's also a student residence. If you come out where the dancers I saw last night have to come out at the back, you immediately come upon a student residence. I would also suggest that the committee is guided by residents' concerns that allowing a licence for a sexual entertainment venue so close to students' residence and so close to the school that you've already heard of, and I've seen with my own eyes students spilling out and down Old Christchurch Road. I'm not saying that there wasn't anyone going towards the Lansdowne, but I've seen students spilling down Old Christchurch Road in the direction of the square, past the 3 strip clubs. I suggest that by allowing sexual entertainment via licenses in this area, you're giving a green light to any pub which becomes empty or other premises that becomes empty in your wards being targeted by this industry, which is always looking for premises, and setting up, say, if Councillor Howell had been here, I would have said Cool High children could have been walking past a sexual entertainment venue on the way to the bus station where there's an area awaiting redevelopment. And I would suggest there are other places in all your wards where this might happen, and that you need to send, I would suggest you consider sending a strong message that sexual entertainment venues and the presence of children, particularly unaccompanied, in the street. I'm not suggesting they go into these venues at all. That's not my objection. It's the fact that they are walking past a 24/7 licensed sexual entertainment venue. With regards to the state of the premises themselves, I note that on a quick inspection that they don't look too bad at all compared to last year. However, on the day of the attempted murder outside the club at closing time, I happened to be in the area a few hours later, so there were enough police around for me to feel confident to make a close inspection, and that's where I saw the plank above the window of 140 was sagging. Now that 140 window, I can't even see it in the plan of the premises, but I'm not an expert in interpreting plans. I also say in my objection that there doesn't appear to be a lift marked anywhere that would be making the premises suitable in this day and age for people with mobility issues. As far as the suitability of the operators, you will have seen in my objection that quite soon after taking over the licence of FYEO in Southampton, a very unpleasant incident was reported to the police, resulting in closure for some time of those premises. Now, I've heard that trusted employees will be taking money, so I've had a look at the company's house documentation to see only one employee noted. So I would suggest that he or she is going to be jolly busy nipping between the Southampton premises and Bournemouth premises, taking payments all night. I've seen within the papers, which I looked at last night, that actually the instructions to the dancers are that a waitress collect, well, nothing against waitresses, but we have been told elsewhere in official documents there's only the one employee, or receptionists will collect payment, and also that the dancers themselves apparently collect payment. Don't know quite how that's achieved. So I would suggest that there is considerable confusion over how payments are collected. I also say that the operators are not suitable for operating these premises because they have put this window display in place, which makes it quite clear in very large letters, people even driving past, let alone walking past, can see that there is table dancing happening there. You will see if you take a tour of strip clubs around the country that in some areas there is absolutely no indication whatsoever of the nature of the entertainment on offer. And I was shown a suggested condition yesterday for one in Yorkshire, which you may hear more of later, which seemed very comprehensive as to not be showing in the window quite what entertainment is it on offer. I've also looked at the Bristol clubs and they don't seem to advertise what's on offer there in the window. In addition, I was intrigued when I was looking through the papers yesterday, and this I believe is a reflection on the operators, that there are in the notice to dancers, there's some sort of suggestion that grown women running around the club and or banging into the waitresses carrying drinks is such a problem that it has to be included in the rules or notices, or whichever one it was I saw it in. Now, I've spent many happy hours dancing in clubs, not recently, and they may have changed since my day, but I never noticed grown women running around. Didn't really notice much barging into people either. And I'm quite concerned that people working there are at such risk of running around or barging into colleagues that this has to be a rule. Spatial awareness in a tiny space in the booth for a private dance is imperative. Now, how can performers who are at risk of having accidents running into people or knocking over waitresses' trays be trusted not to breach the terms of the licence and terms of the law by coming too close to their customers? And that's my objection. Thank you.
Thank you, Mr. Stockwell. Do members have any questions at all for Mr. Stockwell? Councillor Kelly?
Not at this time, Chair.
Thank you. Councillor Richardson?
No, thank you.
Thank you. Are there any questions from the applicant to the first objector at all? Ms. Palmer?
Yes, sir. Thank you very much. I shan't respond to the issues to which I have already responded, either in the initial response or subsequent emails, because you already have those responses. But there were a couple of comments made that I would like to answer questions on. You asked, or you said, Ms. Stockwell, about the students having a place of residence over the club. Are you aware that that student accommodation has been used as such for just about as many years as the club has operated?
I have no reason to doubt that, except that I've been unable to find it, but I have a vague recollection, and again, this may not be accurate because I wasn't able to find it in the planning search, that that there was planning permission to extend that student use recently. Now, I may be confusing it with a different premises, but I did go back, revisit the planning file, and I couldn't find it. So it may be that that was another building nearby.
Thank you, Mrs. Stockwell.
Thank you. And can I'm sorry, Sarah, go on to two more questions, if I may. And you asked the committee to be guided by residents' concerns. Are you aware that, in fact, no resident has made any objection to this application?
I'm aware that no objection which has been accepted as valid by the officer has been made.
Thank you, Mrs. Stockwell.
And again, sir, you indicated to the committee that you were concerned that by allowing the licenses in this area, it would be a green light for any other establishment of a similar nature coming into the area. You are aware, are you, that any applicant would have to go through a rigorous application process and be considered for a grant by this committee, and the mere fact that others were in the area would be no guarantee, in fact, almost the opposite of a grant?
Mr. Stockwell.
Well, I think you've contradicted yourself, because you've already said that the fact that Wiggle has been licensed again this year is a green light to your client being licensed this year.
If I can intervene, Mrs. Stockwell, I think I recall you saying new venues, not existing venues.
Ah, yes, I take that point, Mr. Chair.
Thank you.
Yes, and in fact, I was referring much more not to issues of new licenses in this particular area, but I was mentioning those in the wards of the councillors here present on the committee, who I don't believe, I'm not sure of one, but I don't believe that two of them at least have wards which are in central Bournemouth. I'm suggesting that an applicant in their own wards.
Can I draw
Yes.
a line under this
Yes,
particular
of course.
point? I'd like to move on. Can I ask Councillor Northover if she'd like to address the committee, please?
Hello. Yes, I would, please. I've written out all of the points in my objection, but I would just like to expand more on, firstly, that my objections are about the location, and we've spoken about children at the new school, but I just want to point out that there are children who have a right to be able to use that area. There's many children who live directly in that area. Children live above shops, and children live in the numerous flats that are in that area, and will continue to do so more, because more flats are being built in the town centre, and that is something that the council is looking to happen. We talked earlier on, there was a mention about Wiggle being licensed in June, but even talking about the safety of that area, and this is the main reason I feel the area is has become completely unsuitable, is the number of sex attacks in the area has risen absolutely. You know, it's really concerning that they've got sex offences up 59% and rape up 87%. I don't think we had those figures back when we looked at the Wiggle licence. So this is information that we've had since, and I think that those statistics are really shocking, and I don't know exactly what we're doing to make that area safer, but continuing the licensing of a business that objectifies women cannot surely sit with trying to make that area safer. And then further to that, also since June, we've had yet another rape right opposite this premises in Horseshoe Common, which adds to a number that I have laid out in my objection. So I think, how do we change what this area has become? And I think this is one of the things we need to tackle. I know that we have said that the police have not made an objection. The police will only have the data about the incidents that happen inside the club, and they're the only incidents that they will relate to this club. And I'm not talking about what's happened inside the club. I'm talking about the effect of having sex establishment venues on the wider community and the area around this club. I think I did an FOI recently, and the police have told me that there had been one report of a sex attack inside this club. So I have that FOI. I can forward it on to anybody. I got that information from the police in September, and it lists how many attacks have been reported in about 20 of the clubs in the centre of Bournemouth, if anybody wants that. So I think that this club creates a hostile environment for women. This is something, you cannot have an area that is hostile to a group of people, women, who are a protected characteristic in the and need to be considered in the public sector equality duty. I don't know how you can square this and give this club a licence when it is contributing to that hostile environment. And I just want to point out that as the evening goes on and other clubs close, we do get to the point where more clubs that are open, once you get to between 5 and 6 a.m, more clubs are sex establishment venues than none. So by that point, most people that are going to be coming out of clubs will have just been in one of those venues, and that is the time that some women are getting ready to go off and do early shifts at work. And I think it's an unacceptable situation that they will be bumping into people that are most likely to have just recently been watching women for this purpose. So those are all the points that I wanted to make. And if you want to see the Freedom of Information request with that report, I will forward it on. Thank you.
Thank you, Councillor Northover. I'll be happy if you could forward that email to the clerk, please, so that members of the committee can peruse that. Are there any questions for Councillor Northover? Councillor Keddy?
Not at this time, Chair.
Councillor Richardson?
No, thank you.
Any questions from Mrs. Stockwell?
Yes, it's just a quick one. I was wondering if the notice to all dancers regarding the danger posed to them by their customers outside of the premises, which I came across last night in the information pack, reinforces your concerns about safety outside the club.
Yeah, I did see that, and I think I might have made the point, but I think if it's seen to be dangerous for women who have been working in the club, I don't understand why it's beyond people to see that it's dangerous for other women who have not been working in the club and have nothing whatsoever to do with the club, and furthermore may not even recognise somebody who's been causing a problem in the club moments before. So I think if we can recognise there's a danger to dancers in going on to be in the local area and go to other clubs, I think we can recognise that there is a danger to any woman who wants to be in that vicinity.
Thank you, Councillor Northover. Ms Palmer, did you have any questions at all for Councillor Northover?
Yes, indeed, sir. Several. Thank you. Firstly, sir, going back to the allegation that there has been a sex attack inside the club that was raised earlier by Ms Northover, we responded by indicating that we had absolutely no knowledge of that, and it should have been at that juncture that any further information, including this freedom of information that is referred to now, should have been forwarded to us so that we could have looked at it and commented on it. And so, with the greatest respect, I am not happy that that is now going to be put before the committee at a post event, as it were, without us having an opportunity. We are and continue to be entirely unfamiliar. We know nothing about this allegation, and I feel convinced that we would have been very well aware of it had any such thing happened. So, question. So, Ms. Northover, sorry, that should have been a question. Was there any reason why you did not send that document to us when we had responded in the way we did?
No particular reason. I just didn't think that.
Okay, thank you very much indeed. Also, with regard to the safety of the area and the sex attacks, with regard to the one on which you focused, the rape in Horseshoe Common, pleased to note that the police did in fact arrest somebody, and that continues to roll on, and that was back in August, of course, as you, I think you said September, but it was August. With that and the other two rapes in the year, one was in October last year, the other was in February this year, in the area. One was Wotton Gardens, one was Lansdowne Road, as you know. None of the perpetrators have been identified as being people who were in FYEO. Once again, I am convinced that if they had been, there would have been some very close questioning of their behaviour whilst they were at the premises prior to the allegation of the attack. Do you accept that there is absolutely no indication that these men were customers of my client's club?
Ms. Palmer, Councillor Northover, just one moment, please. Ms. Palmer, your question should have been to Councillor Northover with regards to the information, but we're not cross-examining objectors here. So can you just repeat the question for the committee so they can understand exactly what it is you're trying to request Councillor Northover to answer? Thank you.
Thank you, sir. Councillor Northover, do you accept that there is no evidence that the perpetrators of the 3 rapes to which you refer in the area came from my client's club?
I'm not suggesting that they came from any club, but I'm suggesting that the existence of businesses that objectify women create a hostile environment in that area for women and encourage the idea that it's okay to objectify women. And this is one of the things that is recognised in something that leads to abuse of women and can lead to an environment where men think it's okay.
Thank you, Councillor. Thank you, Councillor Northover. Ms. Palmer, did you have any further questions for?
Yes, sir, just the one, you'll be pleased to hear. You indicated that there had been an increase in violent crimes, in which the sexual crimes are now included in statistical terms. Are you aware that the Bournemouth violent crime statistics actually show a reduction of 4.6% over last year?
If that's a reduction, is it a reduction in violent crime you're talking about?
Yes, yes.
The statistics I have presented are I asked them to separate violent crime from sexual offences so that we weren't confused by whether or not violent crime was included in those. So that is where those statistics have come from. I've specifically asked for sexual offences in the town centre of Bournemouth in the last 5 years so that we can see very clearly, and it shows very clearly that they've gone up a lot.
Thank you, Councillor Northover.
Sorry, sir, just one very quick question. Was there any reason why we were not made party to that information, which is not publicly available or generally
That's
available?
that's the information in my objection. I've copied them there.
Yes, but you haven't given us that breakdown provided by the police.
In what sense have I not?
You've not given us the details, the specific details that the police provided.
That's all of the information they have given me.
That's it. Okay, thank you very much.
Thank
So
you.
no further questions.
Thank you. Okay, at this point in time, are there any further questions from the members of the committee at all?
I do have just one question. When I passed by the venue yesterday, I noticed that there were 2 crowd control barriers at the front of the venue. These had banners attached to them, which were displaying details and moderate graphics of what goes on within the premises. I'd like to know at what time those barriers are set out and removed. Yeah, I would like to know at what times those barriers are set out and removed.
Ms. Palmer?
Just open.
So thank you. They are in situ during the club's opening and closing hours, and the club opens between 10 and 4 on weekdays and 9 to 5 or 6 if there's enough customer interest at the weekend.
Okay, just to follow up, regarding your response to the table dancing text at the front of the venue on the permanent signage, you responded that there's a need to let people know what is within the premises. Would you agree that there isn't really a need to let people know what's on within the premises when outside of the hours of operation? And really, the display details on those temporary banners should be sufficient.
I think, sir, that it's a marketing matter. It is a difficult economic environment at the best of times, and it is only fair, I would respectfully submit, that any operator of any business is entitled to let the public know what that business is.
Thank you.
Thank you, Ms. Palmer. Councillor Richardson, did you have any further questions at all?
Yes, very briefly. The customer code of conduct, how do you alert customers to that code of conduct?
The code of conduct is published at the entrance to the premises, and it is also published on the tables. I'm just checking whether there is any other means of publication.
Code of conduct for the customer is displayed in each dance booth.
Also displayed in each of the dance booths.
And also on reception.
And at the reception desk. I said at the entrance, but also at the reception desk.
Thank you.
Thank you, Ms. Palmer. I think at this point we've heard enough for the committee to.
Can we just talk about because we go to so basically
right. Okay.
I was going to just
Ms. Palmer, I've been advised by the legal representative that we have received the information, and so Mrs. Cole will explain to you the information, and I'm sure that will be forwarded on in hard copy as well. Mrs. Cole.
Mrs. Palmer, so I've received the email from Councillor Northover. It is a list of all the different premises, not just the this type of premises, but the different premises within the town centre area, some hotels, other premises, and I don't want to mention them, you know, while we're working here. And it's just a list of, it's just got a count of sexual offences recorded. The information has come from Dorset Police as part of the Freedom of Information request. We can forward that to you so you can see what the members will be able to see, but that is literally, it does record one sexual offence recorded against For Your Eyes Only. So shall I send that to you and you can, oh, you should have received it.
Thank you. Yes, thank you. Thank you very much. I'm afraid I've not got my laptop with me, but could you just tell me if there are any dates against that information?
No, it's literally 2 columns. There is a list of all the venue names, and then the next column is just count of sexual offences recorded.
And is there any period over which this was?
There is a period, the 1st of the 1st 20 to the 21st of May 23. I'm happy we can send it. Is there an email? Are you at the firm? Are you in an office?
I'm at my client's premises. So if you could kindly send it to Mr. Alex Ivins, that would be helpful. Thank you.
Yeah, could you just send me that email address to my, oh, we're sending it to you now.
Thank you. It's all right. Yeah.
Okay, right, we're at the point now where I will give the opportunity for all parties to sum up, and I will begin with Councillor Northover, please.
Thank you. I don't have an awful lot more to say, just to reinforce that I believe that this committee must ensure that there is no place in any part of BCP where one group of people, in this case women, feel that it's a hostile environment for them. And I think if you're looking at the marketing outside the venue at whatever time, I think this can contribute to it. So I hope that, you know, even if it's temporary marketing that comes out, there needs to be thought as to whether or not that's going to make women feel uncomfortable, or that it's encouraging the idea that you can objectify women or purchase any sort of sexual service or anything from women, which is the issue that I think could come about from that. So that's all from me. Thank you.
Okay, thank you, Councillor Northover. Mrs. Stockwell.
Thank you. There are just 4 points, I beg your pardon here. The first is just picking up on the suggestion that there are applications for new premises and applications for existing premises, and they'd be dealt with differently. I suggest that, and I'm sure your legal advisor can advise you on this and correct me if I'm wrong, that because there is a requirement for an annual license can't go on for more than a year, that the legislation is saying that you look at this every year with fresh eyes. And in fact, I don't have it at my fingertips, but I have seen case law saying that every committee is entitled to take a fresh look at the circumstances of the grant of a license. And so a new premises would not be any different, but that is something again for someone else to advise you on. I'd also like to draw the committee's attention to the legislation which states that an objector only needs to give a general indication of their objection. And so this implication that we've heard from the applicant's lawyer that objectors need to behave as if they are in a court of law, where great lists of what you're going to rely on and what you're going to say and what your witness statements are necessary, are not a requirement for your hearing, and that you, I would suggest, don't look unfavourably on any objector who has done less than who has only done a general indication in their objection. Also draw your attention to the applicant's lawyer's statement that there is no indication of any of these crimes or sexual assault or other violence, in fact, being in any way associated with this club or any of the strip clubs. Now, I'm open to correction, but in the documents I've seen that have been filed regarding how clubs run, how the people visiting the club as customers behave, I didn't see anything suggesting that their identities are all recorded. Yes, the dancers, careful note taken of their identities in the documents I've seen. I don't see, and again, it's for the applicant to correct me if I'm wrong, don't see any list of people who have attended that the police might be able to use in the case of assaults outside venue. And lastly, I'm concerned to hear about the crowd control banners which have been admitted to exist and be part of marketing. My concern is that I don't see them mentioned anywhere in the plans submitted. And I would just like to suggest that use of barriers on something other than the premises forecourt requires a pavement licence from the Highways Department. Thank you.
Thank you, Mr. Stockwell. Ms. Palmer, would you like to sum up on behalf of your client, please?
Yes, sir, indeed. Thank you very much. May I just very briefly have a look at the document that has been sent through to my client before I do that, in case I wish to comment on that?
Yes, indeed. That was just one quick one. It's a generic it's just a list of
Okay. Thank you very much, sir. That was very helpful, and I'm grateful to all concerned for the care that's been taken. So, with dealing firstly, if I may, with regard to the email that has been sent through, I accept, having read that Councillor Northover is right in saying that there is one recorded in that period, that 5-year period, against the club. I continue to say, and so do my clients, that we have absolutely no knowledge of it. So it is also noted from that list that very much higher numbers of such assaults are recorded against non-SEV licensed premises. The SEV licensed premises actually come out of it very well. The clubs, some of whom record up to 17, don't do as well. So the link with respect is perhaps not as positive as may have been considered by the objectors. So summing up now, firstly, may I say that my clients and I respect both Councillor Northover and Ms Stockwell for their opinions, but of course we do not agree with them. They have both put in a tremendous amount of work in bringing information to you. But sir, with the greatest of respect, you will please need to consider, as Sarah Rogers said earlier, the licensing provisions that relate to this application and not extrinsic other issues. And please bear in mind that there have been no objections to this renewal from the responsible operators, nor indeed from some of the establishments that have been raised in the course of objections, including the Livingston Academy, the students, or any of their representative bodies, or any of those living or working in the vicinity. Once again, I say with respect that there's no evidence before you to justifiably support a ground for refusal of this application on the basis that there has been no material change in the location, in the character of the locality, nor use to which premises in the vicinity are put. And we would respectfully submit that the layout, character and condition of the premises is not an issue. In fact, to the contrary, sir, the evidence before you supports, we would say, a renewal on the same terms and conditions. And excuse me, and it is that which the applicant respectfully seeks today. So lastly, sorry, but not least, Mrs. Stockwell commented that there were no lists of customers kept to assist the police in identification. So that is right, there are no lists, but there is a very extensive CCTV system which the police often use for assistance with regard to unrelated matters in the outside area, because it is so good and so helpful. It also covers the whole of the inside of the club. So thank you.
Thank you very much. Thanks to everybody this morning for addressing the committee. The hearing will now conclude. The subcommittee will deliberate in private with the legal advisor and the clerk present. Notification of the subcommittee's decision will be given where possible within a period of 5 working days, beginning with the day or the last day on which the hearing was held. The notification of decision will include information about the right of appeal as appropriate. I will now ask all parties to confirm agreement on the proposed procedure, or if not, please make representations. Yeah. Okay, thank you very much. All parties may now leave. Thank you very much. Right, members, the next item on the agenda is the exclusion of public and the press. Can I have a proposal that we go into exempt session, please?
I propose that we go into exempt session.
Thank you.
Chair.
You happy to second that, Councillor Richardson?
I second.
Thank you very much. On